has warned that the recent court judgments against her will negatively affect the operations of her office. In one of them earlier today, the High Court in Pretoria ordered that Mkhwebane pay 7.5% of the costs in her personal capacity and her office 85% in the case which relates to her Vrede Dairy Farm report, which was previously set aside. To discuss this now further, we have on the line legal analyst Ulrich Roux. Ulrich, good afternoon to you. Thank you so much for joining us here on SA Today. Now, after all the rulings against the Public Protector, can one say this is, in a way, a reflection of a knowledge or rather the interpretation of the law?
Well, that is a very valid question because the court actually found that she interpreted the law incorrectly. But secondly, also that she didn't perform her duties as a public protector. She didn't investigate the matter thoroughly. She did not even look into the third accused person as it is, or the third person implicated in the investigation. And that she basically didn't do her job properly is what the court found. Accordingly, awarding costs against her in her personal capacity again.
Yeah, and also losing so many court battles, what does this say particularly about the kind of advice and perhaps the cooperation from some legal minds working in their office?
Yes, well, at the end of the day, the buck stops with the Public Protector herself, Advocate Busisiwe Mkhwebane. She obviously has a team which advises her. But at the end of the day, every single report that is issued by the Public Protector's office is personally signed by her. So one can then only assume that she has personally approved the report and that she has approved the investigations conducted in compiling the report and that she stands by the report. So, one can argue that she's being ill-advised, but at the end of the day, she is legally qualified. She is a qualified advocate, and she must ensure that when she releases a report that it is 100% factually correct and that her office, which she is head of, has conducted a proper and thorough investigation when compiling that report.
And looking at today's judgments, really, do you believe she can lodge successful appeals?
No, I don't think so. I think if you look at the reasoning of the judge when handing down the cost award today, it looks sound to me, and I don't think that a higher court will reach a different conclusion. She specifically made mention of the fact that the Public Protector made use of two different sets of counsel. So she appointed two different sets of advocates when she could just have appointed one. Remember that this application was brought by the DA and by SADC, and she appointed two different counsels to deal with the two different parties, which is, running up of costs tremendously and unnecessarily so. So I don't think that she has much hope of a different court reaching a different conclusion, to be honest.
And also taking into consideration everything that has happened, including, of course, the court cases that she's lost, do you believe that the Public Protector can still redeem herself as a Public Protector?
At this stage, it certainly does not seem so. One tries to remain objective in these issues, but the fact of the matter is that the Public Protector is in court the entire time. Reports are being queried the entire time. She is having to litigate the entire time because her reports are being taken on review, and she's having costs awarded against her. And at some stage, she's going to have to be given an opportunity to focus on her job, and she can't do that now because she's having to defend every single report that's being issued. So I would be surprised if she is able to redeem herself. I don't think that much credibility can be attached to the current status and position of the Public Protector, to be honest.
And at the same time, you have her office coming out this afternoon saying, in fact, warning that the recent court judgments against her will negatively affect the operations of the Public Protector's office.
Well, that's an absurd statement because then if her office argues that point, then they must ensure that the reports that they release are properly conducted and investigated reports, because then she won't have to spend all her time in court. And I mean, it's not a good position for the public protector to be in, but also not for the society to be in, and for the community's confidence in the public protector. Every report of late has been taken on review, has been queried, and has been found, numerous reports, as we know, by the High Court to have been faulty and wrongful. And unfortunately, a very high bar was set by the previous public protector, Thuli Madonsela, and up until now, the current public protector certainly has not been able to maintain that level of investigations that was conducted by a predecessor.
Yeah, and you've got some NGOs as well who have already made calls for the public protector to be struck off the role of advocates. Accountability, now we know, of course, they've made that call. So looking into these judgments, Ulrich, can one say that they sort of strengthen the case for the calls that have been made that the public protector be struck off advocates' roles?
Well, that's a completely different test that needs to be conducted. Remember that she is on the practicing role of advocate, and that she must be seen to act in an ethical manner in order to remain as an advocate. The reason why certain NGOs have called for her to be removed was because of the fact that a recent judgment found her to have lied under oath in one of her reports, and in certain pleadings before court. So that is a completely different investigation, if one had to compare it to the fact that at this stage it unfortunately seems as if she's just inadequate to perform the duties expected from the public protector. So, one cannot say because her reports are being taken on review and because the High Court has found numerous of them to be wrong in law, that she should be struck from the role of advocate. It's more a case of if it can be proven that she's not a fit and proper person to be a registered advocate and that she lied under oath in pleadings before court, then that is possible grounds for it to be struck.
All right, Ulrich, we'll leave it at that for now. Thank you so much for coming through. Legal expert there, Ulrich Roux, joining us on the line.